Please be seated.
We will hear Jacques versus, United Faculty of Florida versus Florida State.
May it please the Court, I would like to reserve 5 minutes for rebuttal. My name is Thomas W. Brooks. I represent the United Faculty of Florida, which is a union that represents faculty at the Florida State University. Your Honors, this case presents an issue of statutory interpretation by the Public Employees Relations Commission, which is clearly erroneous and constitutes an abridgment of the constitutional right to collectively bargain guaranteed under Article I, Section 6 of the Florida Constitution. Section 447-3091 of the collective bargaining law prescribes the obligation to bargain when the employees choose to have a union. And it requires that the employer and the union bargain in the determination of the wages, hours, and terms and conditions of employment of the employees in the bargaining unit. The term wages, hours, and terms and conditions of employment are also known as mandatory subjects of bargaining, meaning those subjects which the employer is required to bargain with the union about, as opposed to it's simply permissive to bargain about. Now, of course, a union can waive that right to require bargaining before in the determination of a particular term and condition of employment or mandatory subject, but the employer cannot compel the union to waive. In that situation, this case really presents the situation of where a union chooses to waive for the term of the agreement some portion of its right to bargain over the subject of wages, the critical subject of wages. What happens to that provision when the contract expires? Now, we lawyers and judges learn in contract law that when two parties enter into a contract for definite duration and the contract expires, and unless those parties have specifically agreed in the contract that some aspect of their agreement extends beyond the term of the contract, it ends. A good example would be a non-compete clause in an employment agreement. That is the general rule in collective bargaining agreements as well as to everything but these mandatory subjects of bargaining. Contrary to what's intuitive to lawyers understanding contract law, not as a matter of contract law, but as a matter of policy, the law requires that the mandatory subjects, provisions establishing, determining mandatory subjects, wages, hours, terms, and conditions, continue. There's a presumption that they continue when the contract expires during what's called the hiatus, and that is while the parties are bargaining for another agreement. Now, of course, if the parties for some reason aren't bargaining for another agreement, then perhaps everything expires. But what we're talking about here is the hiatus. That is a policy issue which PERC adopted, and the courts have confirmed from the national, practice of the National Labor Relations Board. There's really no dispute in this case that only mandatory subjects survive the expiration of the contract. And there's also no dispute, and it's been established by this court and the Supreme Court in the Palm Beach Junior College cases that a provision by a union waiving some or all of the right to bargain over a mandatory subject is a permissive subject of bargaining, not a mandatory subject of bargaining. Therefore, logic would dictate, one would think, that a permissive subject as a waiver provision would not survive the expiration of the contract. And that, of course, is what has been the law at PERC, and that's until recently, and it's, of course, what is the law under the National Labor Relations Act on which most of these principles are based. But one would be wrong, according to PERC. PERC says...
Mr. Brooks, excuse me. How do you deal with Volusia County Firefighters Association?
One, it's wrong.
Well,
two, it did not.
Maybe it's wrong, but it's been wrong for more than 10 years, huh?
Right, and I understand that. And what
it relied on the city of St. Pete Beach.
Correct. Well, here I can tell you, Volusia County, first of all, did not involve a hiatus negotiations between two parties to the same agreement during a hiatus, and that's why. What was said about this provision in Volusia is dicta, and I've said in my brief it's wrong dicta, but in any case it's dicta because when a incumbent union disclaims interest, in other words, walks away from the relationship, and there's no union for a period of time, and there's a contract, and that contract expires, and then when the new union comes in, there is no contract. The status quo is you're not in a hiatus period. So that principle that the provisions of the contract extend while the same parties to the agreement are negotiating a new one doesn't apply. In that case, you look to determine the status quo, which is what we're talking about here. What are the terms and conditions of employment that are extant? You look, whatever the employer has decided to do during the time that the old union went away and the new union came in, that's what you look to determine the status quo. It has nothing to do with a hiatus, has nothing to do with any obligation extending from the contract per se. That were the facts in Volusia County. The statement in this case that sort of set this whole thing in motion for these many years, Your Honor, was in a boilerplate language describing the sort of general obligation to bargain, somewhat like I've described it here. At the end they said, and a waiver provision, a waiver continues even after the expiration of the agreement, cite St. Pete Beach. Well, if you look at St. Pete Beach, that is not what it says. Can you argue that that proposition can emanate from that? Yes, but if you look at St. Pete Beach, it makes no effort to say this is a rule which we're establishing for all waivers under all circumstances. That case says that in a provision which, established the physical examination for firefighters, the PERC there said that the 9 words in that provision that's otherwise undoubtedly a mandatory subject that says the employer shall determine the extent of the examination, which one can argue theoretically at least is a waiver, couldn't be separated, so that was part of the status quo. It survived. It says what it says. I don't agree with it. I think the hearing officer is wrong, but that doesn't matter. You cannot extract from that ruling on those facts to the proposition that Volusia County gave it, which was all waivers survive automatically no matter what. And there has never been any analysis either between St. Pete Beach and Volusia County, which that was a affirmance of a general counsel's summary dismissal, so it wasn't a fully litigated case or anything, or to any subsequent cases which that broad proposition has been lifted in place. Including in the final order in this case, there's been absolutely no rationale of why the rule that I stated, which is in the Duval case that we say in the brief, is not the correct answer. We have no answer from PERC, even suggestion of why that is not a completely wrong proposition.
Let me, Mr. Brooks, if I may ask you sort of a pragmatic question, and it relates to the language of Article 23.9a.
Yes, sir.
I know everyone below apparently treated that contractual provision as discretionary, but it uses the word shall, which to me suggests that once the conditions preceding have been met, it's mandatory. And if that's true, it seems to me that would create an expectation of benefits on behalf of faculty members. And if the university had not continued to apply that provision, would they not have faced an unfair labor practice charge?
Well, no, because there's a long history, and I cite a couple cases where back before the Board of Regents split up into the individual universities, similar provisions, with the exception of the word shall, as you noted, have been held to be waivers, and it's understood here by the parties that was intended to be a waiver. It was intended to give the university discretion whether and how much raise to give in those particular situations, capped by a certain amount. The university finds that.
So the parties have essentially just read shall out of the provision.
Well, I don't know. I understand what you're saying, but PERC, we contend, based upon that, it was a waiver. That's what PERC held. That's not an issue on this appeal. If the court finds that it's not a waiver provision, then it's an entirely different case, an entirely different issue. And frankly, my theory of the waiver thing isn't damaged if it's not a waiver, which was, of course, the same holding that the court had in the Winter Springs case that PERC cites in his brief, that it wasn't a waiver, so the waiver concept, whether it survives or not, doesn't apply. But assuming that it is a waiver, then it has to apply. And I just want to make one quick point on on what PERC's ruling says that I find particularly wrong. I'm sorry. And that is that PERC found that the waiver didn't survive basically because where it was located in the contract. They adopted this language from the hearing officer that said on page Record of Appeal 334, contrary to the UFF, a waiver included in a mandatory subject of bargaining survives the expiration of the contract and forms the status quo. How? This is absurd. How in the world could if it's a waiver, it's a waiver. What does it matter where it's placed in the contract? Is a waiver any less a waiver because it's in the management rights clause or a separate provision labeled waivers as opposed to being in the particular article relating to wages to which it particularly relates? Doesn't make any sense. If this is the level of analysis that has been applied in this case, to which I've been trying to get some sort of make some sensible reply, and I haven't gotten it, and that is just fundamentally wrong. I'm going to save the rest of my time for rebuttal.
Good morning, and may it please the Court. Carolyn Egan here on behalf of the appellee, Florida State University. I would like to waive a minimum of 5 minutes of my time for the agency. The Public Employees Relations Commission has taken the time to intervene, and I actually hope that I will be done before my 10 minutes are up so that I can yield more of my time to Mr. Ruby if that's acceptable to the Court. A couple of things, some predicate things as to how we got here. We have 3 commissioners at PERC, one being management friendly, one being union friendly, and one who is presumed to be neutral. This is a unanimous opinion where all 3 commissioners agreed that this is the long-standing law of PERC, that it was abundantly clear, and that it was abundantly clear when this charge was filed, such that they sent a message by awarding fees in favor of the university. So the university would ask that both parts of the ruling be affirmed.
Let me ask about the attorney's fee issue. You have requested attorney's fees on appeal, but it strikes me you've perhaps not cited the right statutory provision.
If you could be more clear, I understood that the right to appellate attorney's fees was at least in part dependent on your mechanism for obtaining fees below, and on the appellate rule on that subject.
Okay.
In any event, since we're talking about fees, I think PERC felt it was abundantly clear at the time, and that takes us probably right to the Duval County case that Mr. Brooks relies on. And I think that's entirely where the union goes wrong here. The Duval teachers case did not involve a waiver, and the Duval teachers case is entirely consistent with the opinion here. Doesn't have to be overruled in order for PERC to be correct. What the Duval teachers case says is that the threshold test for determining survivability is whether the provision deals with a wage, hour, or term and condition. Here we have a package of wages that were negotiated between the parties on level playing fields, agreed to, ratified an entire package dealing with wages. So under the test set out by Duval teachers, this is indeed a wage provision, a wage package that's part of the agreement. And even under Duval, it would survive. Now, Duval is even a little different, and I think doesn't control here for the reasons stated in the brief, specifically that the issue in Duval was that the provision that was at issue in the Duval case didn't have any benefit to the individual members. PERC looked at the Duval teachers case and said, that's a benefit to the union, to the entity. It doesn't flow directly to the membership. And I think PERC didn't cite the Duval case because it's not on point. It doesn't help. The Duval case is later applied just a year or two ago in the FAMU case that the union has cited in its brief, where there the issue was a benefit deriving straight to the union entity. So in any event, the Duval case under which the union proceeded didn't help its argument any, and as you heard earlier this morning, their position is It's flat wrong. It's plain wrong. I don't believe it. With respect to the fee award, I think PERC wonders how many times do we have to say this before people believe us, and sent a message, and I think this Court should affirm that. In any event, there's a body of law that existed, and the reason that PERC awarded the fees is because there is the body of law discussed earlier, the Volusia County case, the St. Petersburg case, putting the union on clear notice that a wage provision is going to survive if it's part of a negotiated package that is a mandatory subject of bargaining, that is a wage, hour, term, and condition, just as in the St. Pete Beach case. One part of it seemed to trouble the union. One part of it may have been a waiver, may not have been a waiver. Who knows? But it was a part of the package that was negotiated and accepted, and therefore it became a part of the status quo. As Mr. Brooks said, these contractual parties aren't like ordinary contractual parties. Everybody doesn't go their own way when the contract is over. So there has to be some mechanism in place to govern what happens if a contract expires. There has to be some way for the parties to govern themselves. Here we do it by PERC's creation and adoption of the status quo, which means that employees shouldn't be harmed. They shouldn't be negatively affected when the contract runs out. So the wage provisions, including this one, should survive. Now, it seems a little absurd that if this one didn't survive, one has to ask the question, if this provision, Article 23.9, did not survive after the expiration of the contract, did the university need to go and take back all of those increases it gave during the life of the contract? If that part expires and is no longer the party's dealings, you'd have to go take them back.
I expect they wouldn't ask you to do that.
But would that be the university's obligation to follow the law? Even if they didn't ask us to do that, would that be our obligation? I mean, it seems like that's a little absurd to me. Getting back to Judge Webster's question about the employee's expectation and what the effect of the word shall in there. It's a difficult question to answer, and I don't know that it's answered in the record, but it seems to me pretty obvious that an endowed chair is one situation where you get additional pay under this provision when you assume those responsibilities. I feel pretty safe in saying that there aren't many folks who are going to accept an endowed chair and what comes with that without this increase. So I think that shall would certainly be applicable in that instance. They have an expectation. If they're offered an endowed chair position, there is something that comes with that. An expectation exists. And as the cases cited earlier say, the employee's expectation. The employees aren't ordinarily familiar with, well, when's the expiration date of the bargaining agreement? I don't know. My wages are governed by this wage article, Article 23. Let me open it up and see what it says. Well, it says if I become an endowed chair, I get a salary increase. The university shall give me a salary increase. That's what it says. And the cases are consistent with that, dating back to 1993 at least. So I think there is an expectation. I think to say that there's no expectation created by this article is really disingenuous to the ordinary person who's picking it up and reading it. With respect to the Winter Springs case, I'll probably let our PERC counsel address that since he was more intricately involved with that than I was, and probably knows a little more about it. But I cited a case in my brief involving the University of Central Florida, where a wage provision that was very similar to this one was at issue. The hearing officer in that case kind of threw up his hands and he said, I don't know if this provision survives. I'm going to let PERC decide that. I'm going to send that up to PERC because, oh, by the way, we have this Winter Springs case that it's a new case and that'll somehow affect what would be decided here. But I'm not sure what the answer is, so I'm going to send it up to PERC. So unfortunately, at that point, PERC decided the UCF case on other grounds. The commission did not decide on whether or not this provision survived because it decided the case on other grounds. So maybe the law was vague at that point. I don't know. Maybe arguably at that point. But after the Winter Springs case out of this court, and after the AFSCME case, where another contractual provision that was thought to be a waiver survived, there was clear notice that this body of law existed. It should have been fairly obvious. Now, there's certainty provided here. The legislative intent of Chapter 447 asks for harmonious relations between the parties. Certainty is given when wage provisions go on. Employees have certainty, they have stability, they know what's going to happen, there's predictability, and that supports, in this hiatus period, the ability to negotiate in good faith. The record here shows that negotiations were ongoing in good faith. In fact, the record here shows that the system worked. The university, through this hiatus period, administered all of Article 23, including Article 23.9, believing that it should continue to administer the entire wages package. The system stayed stable. Eventually, there was a new contract reached after the hiatus period. I think that's exactly what's intended by the statute. I think that's exactly what's intended by the case law out of PERC. This record shows that the system works. And moreover, there's no rationale for parsing out certain parts of the wage article. We're going to sit down with the wage article and go, well, this one didn't survive. No, this one did, this one didn't. That doesn't promote trust, doesn't promote harmonious labor relations. It doesn't do much to get the parties on the road to getting a new contract. Now, I think you may hear on rebuttal that there's some awful, awful things that are going to happen. I think in the briefs, the union calls this a significant new weapon at the hands of the university. It's certainly not new and certainly not a weapon. This is terminable at will by either party. You can either file impasse or reach an agreement. It's not a weapon. Moreover, if the university didn't pay them anymore, the university would be saving money. But they instead choose to go on with the contractual obligations. And I'll give the rest of my time to Mr. Ruby. Thank you.
All right. May it please the Court, my name is Jack Ruby. I'm representing the Public Employees Relations Commission in this case. Try as you will, Mr. Brooks is trying to characterize this case as another case. This is not a negotiations case. It is a status quo case. We would agree with Mr. Brooks' argument that the employer can't impose a waiver. This is not a case where there wasn't something pre-existing. In fact, there was something pre-existing. And the Delray Beach case is on point to a certain extent, talking about the fact that wage provisions are part of the status quo, albeit that was the other side. That was a union saying, you didn't comply with the status quo in giving us a pay raise that we were due. Here, the employer is giving pay raises that are due to people under a contractual provision that had expired, but under the status quo provision, there's a hiatus that sometimes occurs between collective bargaining agreements, and if the agreement expires and another has not been executed, terms of the first agreement survive the agreement's expiration. Simple, clear. That's what Delray Beach and many, if you read the Delray Beach case, they say this has been held over and over and over for the commission. So this is not a negotiation issue. It is a status quo issue. Then there was a discussion of where do we find the waiver? And there's resentment about that. Well, what happened was the commission seized upon or considered the UFF's argument before the commission and exceptions, and citing the Duval case. And they said, status quo only pertains to things that are wages, hours, and terms and conditions of employment. And the commission in its final order said, this is wages. By definition, it is a mandatory term of condition of employment. Therefore, it survives. Finally, the Winter Springs case. The Winter Springs case was very unusual in the sense that it went a step further. Matter of fact, 10 steps further than this case right here. The commission says, okay, the status quo is there until a new agreement is negotiated. In Winter Springs, what you had was a wage freeze provision that said you get no new wage increases. That includes step payments, which, being in a state employment, we don't get step increases, but counties and other people and even the universities get step increases to their wages, annual kind of increases. But you don't even get those until a new agreement is negotiated. In Winter Springs, what happened was, at the end of negotiations, the employer has the ability to impose an agreement on the other side, albeit it's only effective for a year, but they have the ability to impose an agreement. What happened in that case was the agreement that was imposed the wage freeze provision until a new set of wages could be negotiated by the parties. The Commission said, well, you've kind of gone too far here, overruled its hearing officer, and finding that to be an unfair labor practice. This court decided otherwise. This court said that wage freeze was part of the status quo, and the status quo prevails until a new agreement is reached. What happened in this case right here was the fact that the status quo was different members of the faculty union being able to get pay raises by virtue of somebody coming in and saying, we're going to pay you more if you leave and come with us, or we're going to pay you more because you have a special qualification or something like that. You just got a Nobel Prize or something like that. We've decided that we can give you these discretionary pay increases. The Commission held, pursuant to its hearing officer's decision, that that was a part of the status quo. Time's out. Thank you, Your Honor.
The issue is not whether employees, the employer can continue to give pay raises for endowed chairs and counter offers, et cetera. The provision doesn't stop them from doing that. They're perfectly free to do that. The difference is, during the term of the agreement, the union says, you don't have to come to us and negotiate with us up to this amount. You can do it on your own. We're not involved. We're opting out voluntarily. When the contract expires, they can still do it, but they got to come to us and talk to us about it. That's the only difference. And that is not a wage provision. That isn't the provision. When I said determination of wages, the portion of the article we're dealing with here does not determine any wage. It is a provision that does the opposite. The union waives its right to require a determination with it first and allows the employer to do it unilaterally, but only during the term of the agreement, like any other provision that doesn't fall within a mandatory subject. She talked about the Duval case. Here's PERC's brief, page 8. As argued by the appellant, the question to be answered for determining the survivability of a particular contract clause is the provision a wage, hour, term, and condition of employment? That's quoting directly from the Duval case. Then Ms. Egan.
Mr. Brooks,
yes.
If I understand your argument, it boils down to this article does not relate to wages, therefore it doesn't continue. Is that it?
No. Relates to, and that's the word. It says, is it a wage, hour, term, and condition of employment? And the test does not say, it says, is it or isn't it? That's what was determined before. It doesn't say relates to. Of course it relates to, because that's what you're waiving. You're waiving the right to bargain and determine this wage. Of course it relates to wages. Every waiver relates to or concerns a mandatory subject. Otherwise you wouldn't need it.
In your brief, you made that point about some of the cases that talk about the language of concerning wages or concerns wages. And that isn't, in your view, if I understand your argument, enough.
No, absolutely not.
Because here, can you give me an example of one that would survive, something that would survive? I mean, if it would just actually be that
if it establishes a wage,
that the wage is X, then the contract expires, and now we're in the hiatus. The wage stays X, right?
Right.
That survives. But what you're saying, if I understand you correctly, is that this isn't that. What this is just the ability to negotiate what the wage will be.
Right. Unilaterally as opposed to go through the union. That's what we're talking about. That's what a waiver is. That's what a waiver is. It waives the right to determine through bargaining what the
Wages.
condition is, not whether there will be a raise, but who may get it or how much it will
It
be.
waives the right to determine wages through bargaining.
Yes. And it is either a waiver or it is not a waiver. It can't be both. In PERC's argument, and they keep skipping over with this term, concerns or relates to, that conflates the two. Well, of course it concerns it. That's what we're talking about. You have to bargain about mandatory subjects. So a waiver that relieves you from the obligation of bargaining about a mandatory subject certainly concerns that mandatory subject that you're waiving. Of course it concerns it, and of course it relates to it, because that's what you're doing. But the test, their own test, is it a term or condition of employment? PERC itself, in the Palm Beach case below, this court in affirming and the Supreme Court in affirming the Palm Beach Junior College case said a waiver is not a mandatory subject of bargaining. It is a permissive subject of bargaining. Therefore, it cannot survive under any configuration of the law. And I think you would.
Well, are you arguing then that no waiver can ever survive?
Right. That's what the law is. A waiver of a mandatory subject is permissive, and it can survive if the parties agree this will survive. But you have to say that, just like you have to say in a non-compete situation, this survives the expiration of the employment agreement. The parties have to say it survives. It doesn't survive automatically as a presumption against survival unless the parties clearly intended to do otherwise. And just one word on attorney's fees. I hope the court can see that this is far from a settled or clear issue, that the union certainly had a right to try and get this issue cleared up by PERC. And there should be no furnace fee award in any case. Thank you, Ron.